Welcome back to the channel, and thank you for watching, and thank you for smashing that like button and the subscribe button on the way in. So, two very important points to note about these supposed therapist notes that Amber Heard revealed in her interview. First of all, there is this notion of a self-serving statement. Now, ordinarily, a self-serving statement is not to be admissible as evidence in a trial, and there's a very important reason for that. And to understand that, we need to know what a self-serving statement is. Now, a self-serving statement could be any kind of written statement or document that supports one party's legal pursuit in one way or another, but doesn't actually provide any evidence. In other words, it might be a statement produced by that person, by that party, or by some other party if they have reported certain events to that party and they've made written notes about it. However, it doesn't provide any actual evidence. It is merely a statement that supports their account, but provides no further evidence. It's not photographic evidence, it's not video evidence, it's not any other kind of documentary or any other kind of evidence other than what they say or what they've reported to another party, which purports to support their argument in court. So it's a statement that supports or serves their argument, hence the term self-serving statement. And it's what we refer to as a previous consistent statement. So if we take the premise that, let's say, someone's going to steal a car and they go on to steal that car, but before doing so, they tell people that they have no intention of stealing a car, and they tell them this on a regular basis. So there are lots of different reported documents that they say they have no intention of ever stealing a car. Even then, before the trial or before questioning by the police, they tell people that they didn't steal the car. And so all of these separate statements support their argument that they didn't intend to steal the car, and once it's happened, that they didn't steal the car. All of these are simply statements that support their case that they didn't steal the car. They are all self-serving statements, meaning they support their case, they self-serve their argument that they didn't intend to do it and that they didn't do it. But the important distinction is this: they did not provide any further evidence other than what they say. So therefore, previous consistent statements are normally not admissible and normally not of any real evidential value. So if a jury were to be directed on the value of these statements as they were, as these alleged therapist notes would be, a jury would be told that these have little to no evidential value whatsoever because they are a self-serving statement. That is the first thing of note of these therapist notes. The second thing to note is this, and that is the notion of hearsay. We've talked a lot about hearsay in recent videos, but just as a recap, if you're new to this channel and you've not quite grasped it before, but hearsay is anything other than oral evidence given in court. That is because you cannot test anything other than oral evidence in court. If you or I were to go to court and give oral evidence, i.e., you speak out loud your evidence, and then another lawyer can cross-examine you on your evidence and test your evidence and ask you, you just said this, but what about that? Or the way you just described it is X. However, what do you say about this? And test your evidence live in court. That is oral live testimony, which can be tested in cross-examination. Therefore, it's not hearsay. Anything else is hearsay. If I were to produce a document to you and say, this document says XYZ, that means the truth of it is contained within this document here. However, you cannot test this document. you cannot cross-examine this document. You cannot ask this document about something else that happened a week prior. You cannot say that another person suggested something different, therefore this document is incorrect. You cannot test it in any other way. Therefore, it is hearsay. Hearsay is notoriously unreliable, often inadmissible, and in any event should be less credible than oral testimony from a person given in court, because you can cross-examine the person, you can cross-examine their testimony, you can test their evidence with the veracity of other evidence, other witnesses' evidence, other written documentary evidence, and put their testimony under pressure so that any judge or jury can make a reasoned determination as to the credibility and the value of their evidence presented in court. You cannot do that with a written document because you cannot test it. So these alleged therapist documents will not only be self-serving statements, as we discussed just now, but they will also be hearsay. Because if they attest to the truth of any matter stated, they, as in the notes, cannot be tested in cross-examination. So that is why these therapist notes were ruled inadmissible on both of those counts, no doubt, and why any jury would be, in any event, directed to rule them as less credible than any oral testimony that they heard in court, such as Amber Heard, Johnny Depp, and each of their respective witnesses. So I hope that helps to address one or two of the questions addressed by these therapist notes. But there is a third, and that is the duty to report. That is coming in my next video. The duty of confidentiality, both from a therapist and a lawyer. And it's known as the duty to report. That's coming up next, so make sure you subscribe and like this video and hit the bell icon to receive that one. Thank you for watching.